In the matter of the Principal Chief Conservator of Forest versus Suresh Matthew, Supreme Court allowed the appeals and set aside the judgment and order dated 19th of January 2021 passed by High Court of Kerala at Ernakulam in writ appeals. The factual matrix of the case was that Divisional Forest Officer Koni issued an order dated 12th October 2020 cancelling earlier e-tender notification dated 25 May for final tree felling works of 1954 Neliddapara in South Kumaremperur Forest Station under Koni Range in Koni Forest Division and decided to float a tender afresh. Writ petitioners were participants in earlier e-tender notification dated 25 May 2020, and according to them, the action of the appellants to re-tender the work after cancelling earlier tender was arbitrary and illegal action. In fact, the principal conservator of forests issued a circular dated 29 February 2020 in regard to renewal of registration of A-class contractors, wherein it was stipulated that A-class registered contractors who have not participated in any of tenders notified by department for timber extraction during last financial year are not eligible to get renewal of the A-class registration. Court said that we may state here that if our observations are seen qua the touchstone of questions framed by this court in judgment of Jagdish Mandal case, the answer would be in negative. Therefore, decision taken by authorities cannot be termed as a mala fide decision or a decision to favor some. At cost of repetition, we may state that the decision of the authority is giving a fresh opportunity to all interested bidders to compete with each other in the process of fresh selection. In our opinion, decisions taken by authority is not affecting the public interest. On the contrary, it furthers the cause of public interest and fairness. The question of scope of judicial review in cases of award of contracts has already been dealt with by Supreme Court in case of Jagdish Mandal versus State of Odisha and others, wherein the court observed judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and mala fides. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders of or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interests, court will not, in exercise of power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to invoke to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical or procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interferences, either interim or final, may hold up public works for years or delay relief and succor to thousands and millions and may increase the project cost manifold. Therefore, a court, before interfering in tender or contractual matters in exercise of power of judicial review, should pose to itself the following questions: whether the process adopted or decision made by authority is mala fide or intended to favor someone, or whether the process adopted decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached. Whether public interest is affected. If the answers are in negative, there should be no interference under Article 226. Cases involving blacklisting or imposition of penal consequences on a tenderer or a contractor or distribution of state largesse, allotment of sites, shops, grant of licenses, dealerships, and franchises stand on a different footing, as they may require a higher degree of fairness in action. Supreme Court said we are of the opinion that High Court has committed a gross error while observing the facts in the case of Jagdish Mandal were entirely different in regard to a defective tender submitted by a participant. The law regarding government contracts or auctions and the nature and scope of its judicial review is well settled. In the case of MS Michigan Rubber Limited versus State of Karnataka and others, Supreme Court observed the basic requirement of Article 14 is fairness in action by the state, and non arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to the judicial review only to the extent that state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. In the case of Tata Cellular versus Union of India, Supreme Court emphasized the need to find a right balance between administrative discretion to decide on the matters on one hand and the need to remedy any unfairness on the other. The division bench of the High Court, which upheld the judgment of learned single judge, was of the opinion that merely because there was likelihood of rates being lowered if successive tenders are invited, the same cannot be justifiable ground at all for cancellation of contract, since it would lead to situation of unending tender inviting procedure. However, Supreme Court said we are of the opinion that said observations by High Court are contrary to settled principles of law laid down by Supreme Court that government is the protector of financial resources of the state and thus it has every right to cancel and call for fresh tender if it is in the nature of protecting the financial interests of the state. It is noteworthy that order dated 12th October 2020 is an order, in this case issued by DFO, who is competent authority. Setting aside of this order of DFO by single judge is erroneous, and since it does not record any finding that the order of DFO is mala fide, we are of the opinion that order of DFO would give an equal opportunity to all the bidders, and thus there would be a fair play between them, ultimately benefiting the government.